Welcome back to the OMB Law Board. I'm Simon Bennett. Today I've got Erlinda Nunn with me, one of our solicitors in our property law team. Welcome back, Erlinda.
Thanks for having me, Simon.
So, Erlinda, you've spoken to us previously about property-related matters, and today I wanted to talk about some of the contract requirements and, particularly around paying a deposit. So, what are some of the issues you see around what should be a fairly simple task?
The biggest one is paying the deposit on time. Generally, in a contract, there may be an initial deposit payable, and in the reference schedule of the contract, it generally says that it's payable upon signing, which is when the parties have both signed the contract, everyone's got a copy. Generally, that date is when the deposit's due. Often there may be a balance deposit payable when the contract becomes unconditional, or it'll stipulate a certain time frame as to when that needs to be paid. There are very strict time requirements in Queensland in relation to paying deposits under contracts, and it's really important to pay them when they're due. Otherwise, a buyer might find themselves in quite a bit of strife.
So, time of the essence, what does that mean? I hear that phrase all the time in respect of contracts in Queensland.
So when they say time is of the essence, it means that when you are required to do something under the contract, you must do it within that time frame. So if, for example, it says the deposit must be paid within 2 business days from the contract date, you must pay it within that time frame by 5 p.m.
And what are the risks to me as a buyer if I don't meet that time frame and pay the deposit when it's due?
If you don't meet that time frame and you don't pay the deposit when it's due, then the seller has a right to terminate the contract because it is a breach of an essential term, and they can sue you for any part of the deposit which hasn't been paid as a liquidated debt.
Wow, that is a big risk.
It is a huge risk because sometimes some of these deposits could be anywhere between 5 and 10% of a purchase price.
Yeah, and that just explains why, our OMB property law team is so strict on compliance with our clients to make sure you've paid your deposit when it's due, and the ramifications if you don't.
That's right. There's even a little trick in the contract as well, that if you have paid the deposit on time, if the deposit hasn't cleared into, say, the selling agent's trust account or the seller's trust account when due, if you have a copy of that remittance to show that you've paid it within time and you've sent that to them, that's deemed as paid.
So if I pay the deposit electronically and I can produce evidence that it's been paid, that will cover me for that period?
It certainly will.
Okay, well, that's a good trick to know, and important, obviously, with such big ramifications if I fail to pay.
That's right.
What else should I be worried about in respect of the contract? What about one that I see regularly is people wanting to take more than 10% deposit?
So then it becomes an instalment contract, which can then vary the parties' rights substantially, and we ordinarily wouldn't recommend it to our clients.
Yeah, the general position with instalment contracts, Erlinda, as you've quite rightly said, is it's something that we try to avoid because it does substantially change the game, and it's not recommended in most situations. So what else should I be concerned about with the contract of sale from that point of paying deposit?
From that point of paying deposit, there may be other things that the contract is subject to, such as finance and building and pest, which we've previously touched on in other episodes. So it's important to get your ducks in a row, satisfy those conditions when they're due so that you can move towards settlement. Once the contract becomes unconditional, either your lawyer or your conveyancer will be doing searches and preparations in the background to get the matter ready for settlement.
And we talked about time of the essence earlier. I presume time is still of the essence in respect of, for example, the settlement date?
It is. It's important that your bank is ready to go on the settlement day, or that you've transferred all funds necessary to complete the purchase, because if you haven't, again, there's serious legal ramifications.
So you could be in default?
You could be in default.
Yeah.
The seller could terminate, you forfeit the deposit, they could sue you for damages, and if there is any resale of the property, the seller can sue you for a deficiency on the purchase price if the property is resold within 2 years.
So substantial problems if you are in default under a contract. There is a recent change in respect to the contract which allows either party to extend for a period of up to 5 days, buyer or seller. Can you tell me a little bit about that one?
That's right. So standard term 6.2 of the contract allows either party under the contract to extend the original settlement date for a period of 5 business days from the original settlement date. That doesn't mean if I'm a seller and you're a buyer, we each get 5 business days. It's 5 business days in total. So if I'm not ready on the date of settlement, I can give you a notice and say, I'm not ready, but I need an extra 2 days. And then if it gets to those 2 days and you're not ready, then you've got an extra 3 days up your sleeve.
Okay, well, that's good to know. And obviously, that is an absolute right. I don't need a reason to invoke that right to extend.
That's right. You don't have to provide a reason to the seller as to why you need that extension, and the seller can't object to your extension request, and they can't enforce any penalties such as default interest during that time.
Finally, I wanted to get on to a recent decision that was made regarding payment of deposits and potential extensions of time. Can you tell our viewers and our listeners a little bit about that?
That's right. So that was the case of Evans and Jan. And what happened was that the buyer and the seller entered into a contract of sale on or about the 22nd of January. The deposit was due upon signing. And then what happened was that the buyer couldn't pay the deposit on time, messaged the agent, said, hey, I've transferred a portion of the deposit. I can't get it all to you today because the bank's being difficult, but I'll transfer it to you over the next few days. So the agent and the buyer had entered into correspondence with each other about those payments being made over a few days. The full deposit was eventually received on about the 25th of January. And during that time, the seller was obtaining advice from their solicitor about whether that had been a breach of an essential term by the buyer. The seller ultimately terminated the contract and said that the reason for the termination was because the deposit wasn't paid when due. And then the buyer sought to bring an application for the contract to be affirmed and specific performance, which would mean that the seller would be required to keep the contract on foot and sell the property to them.
So based on the advice from the agent that I could pay the deposit a bit later?
Correct.
The buyer sought to say, well, I wasn't in breach because I got the extra time from the agent.
That's right. But then the court ultimately held that the agent didn't have actual or ostensible authority from the seller to vary the terms, to vary the essential terms of a contract, to extend the time of when the payment of the deposit was due.
So what was the end result?
So the end result was that the contract was found to be validly terminated by the seller. The buyer lost their deposit, which was $98,500.
Wow. So a good lesson there on the most recent authority is if you can't pay your deposit when it's due, get a formal extension, get your lawyer to obtain it through the seller or the seller's lawyer, and don't rely on the agent telling you that you can pay it late without confirmation, because this poor buyer ended up losing their deposit.
That's right.
What a nasty lesson to learn. But Erlinda, I think our viewers and listeners would have found that extremely informative, as did I. So thanks for coming in and telling us a little bit more about the working mechanics of a contract of sale.
Thanks, Simon.
Fantastic. And we'll see you next time on the OMB Law Board.